Assalamu alaikum. Welcome back from the break. My name is Bilal Khan, and you're joining me on Just Law on Ikra TV. And this is a live call show, and the number will be appearing on your screen right now. So if there's any questions in particular regarding any aspect of criminal law, motoring, or general or complex crime, then you can call in. And like previously advised, I will attempt to provide generic advice, and then if there's any further particular advice that you require, you can contact the control room and notify them and provide them the details, and I will contact you back as soon as possible. Now, before the break, we had a question from a sister regarding a young person being in custody and the rights, and I was explaining the three fundamental rights that you have if you are in custody. The first being to contact and notify a member regarding your attendance at the police station. Second, to consult the codes of practice. And third, to have a solicitor. I understand we have a caller. We'll go to that call. Assalamu alaikum.
Walaikum assalam. I've just got a couple of questions about it. It's just with regard to driving matter.
Yep.
I don't know if you'd be able to. So basically, what happened around 5 months ago, the police were driving behind me and they pulled me over for no insurance. Now, the officer at the time, he told me that they were going to send a letter out in the post, and it's been about 5 months. I've not received anything. Should I be chasing them?
So it was 5 months ago that you received when you were stopped by the police. And
Yeah, that's one of the issues, yeah.
so the police, for any summary offence, they have a period of 6 months to authorise a charge and to issue a postal requisition or a summons in respect of that offence. Now, my suspicion is when you were stopped by the police on the day in question, they spoke to you, conducted their inquiries, and they must have summoned you or reported you for summons. Did they notify you at the time that you should be receiving a summons?
That's correct. The problem was the first. So I had a few problems on that day. So the first problem was I was picking up some food. So what the policeman said was, I suspect that you're driving as a delivery driver. I told him that this wasn't the case. It was for my home. But he told me that you've got no business insurance.
Okay.
And then the second issue, I don't know if you can help me, was the fact that they then decided to do a breath test on me because they wanted to do an alcohol check. Now, I did inform him I'm a Muslim and I don't drink. And I just wanted to know, I told him that I don't want to take part in this test, but he told me if I didn't, I would be getting charged for the offence. Is that correct?
That's correct. Now, failing to provide a specimen for analysis is an offence in itself. It doesn't matter whether you had any alcohol to drink. By virtue of the fact that you've just refused, it's a criminal offence in its own right, and you would have been arrested. So was you arrested on that day as well?
No, because I consented, but I wasn't happy because as a Muslim, brother, we don't drink alcohol.
That's fine. And naturally, the response on the breathalyzer would have been zero alcohol in your breath.
That's correct.
Yep, that's fine. So
I just wanted to know my rights as did I have any rights to refuse?
See, the officer needs to show that he's got reasonable grounds to suspect that you've consumed some alcohol. So if he believes, and the problem we have is what the officer's grounds were. Now, if the grounds were, for argument's sake, or normally what we read on statements is the person's speech was blurred, he wasn't talking properly, they smell alcohol from his breath, etc., and that gives rise to the suspicion Now, if he stopped you and then has asked for that breathalyzer, the fact that it was zero and it's over and done with, yes, you can complain regarding the officer's conduct, but we'll have to take further details regarding that. But you've got a right of complaint. It's been 5 months and you've not complained. That may be an issue regarding recollection, whether or not there's any body cam footage from the officer or any recording available from the police vehicle to confirm that. But if I address the insurance issue with you first, now, insofar as the insurance is concerned, the officer is right. If it was going to be a delivery, I know you're saying it wasn't, but if it was going to be a delivery, you need specific insurance to allow you to drive for that purpose. So, for argument's sake, a business insurance and delivery driver's insurance. Now, the burden on every criminal case is for the prosecution to prove beyond reasonable doubt or to make the court sure of your guilt. So in order, it's not good enough for an officer to say, I suspected that he was doing that. The officer is going to have to turn up to court and say, I believe that he was driving and he was going to deliver food because there was a hot bag and there was a receipt and there was lots of change and it looked as though that he was delivering or something along those lines.
I didn't. It was just, I had no hot bag and I just had the receipt, so it was for my personal family.
Yeah. So the issue there is the first thing is you need to wait for a summons. The police have 6 months to authorize a charge and send you that out. If you've received that after the 6 months, there may be a technicality on which the prosecution has statute barred to bring the prosecution against you, and automatically that case will fall on all fours before it's even in court, because we can argue, wait a minute, the date of offence is this, and the date that the charge was authorised is within this period. So
that is 6 months, you said?
6 months. And that's not the date that you receive it, that's the date that the charge was authorised, okay?
Right.
From the date of the offence up until then. Now, if you do receive it, and it's within that 6 months, then what you need to do is you need to make your plea either online or by letter, and you need to put down the guilty or not guilty plea as it may be. And now what I recommend at that stage you do is contact the control room, get the details for myself, and I can advise you more particular once the evidence is served. The postal requisition will have the charge date, the date it was authorized, and also a statement from the officer. We can go through that and then we can advise you on the merits of your case, whether or not you have a decent case or not.
Oh, so you can deal with this as well, brother, yeah?
Yes. I can deal with it, or if you have another criminal, usually criminal solicitors will be able to deal with road traffic offences as well.
Thank you.
Is that okay?
Thank you very much.
Does that answer all your concerns? Yep. Thank you very much. Now, we was talking once again regarding the rights at a police station. Now, those are your 3 fundamental rights, and it's always advisable to seek representation from a solicitor from the outset of a case in order to advise you on the strengths of the prosecution case and on your defence, etc. Now, moving back to the topic at hand, and the topic was talking about the different courts that we have, and in segment 1 I've already talked about county court, the youth courts, and we were dealing with magistrates court. Insofar as magistrates courts are concerned, the magistrates courts deal with criminal cases predominantly, and also regulatory cases. So for argument's sake, you may have granting or betting, gambling or alcohol licenses, hearings that deal with council tax non-payments, or the appeals relating to taxi licensing, etc. and prosecutions by the RSPCA, by the Food Standard Agency, etc. And it all depends on how serious the case is. Now, insofar as criminal cases are concerned, there are three categories of offences. The first being summary-only cases. Summary-only cases are those cases that can only be dealt with at the magistrate's court. Now, the next set of offences are classified as either-way offences. Now, the word speaks for itself. Those cases can either be dealt with at the magistrate's court, or if the magistrates decide that the sentencing powers of the magistrates are insufficient, then that case will be deemed unsuitable and will go to the Crown Court. The third is indictable offences, those offences which are too serious to be dealt with at the magistrate's court. Now, as a general rule, if you are going to get a sentence of more than 6 months for one offence, or a fine of more than £5,000, then your case will be deemed unsuitable for the magistrate's court, and your case will be destined to the Crown Court. Now, there are cases which overlap, and sometimes you see cases being dealt with in the magistrate's court, sometimes at the Crown Court, and then in relation to those offences, it all depends on the particulars of that case. So the magistrates will look at the sentencing guidelines, they'll have a look at the individual before them and the record or lack of record of previous convictions, whether the person's been before the courts or not. And then they will also look at the statutory aggravating features and the mitigating factors, and they will try to categorize the offence to see whether or not that offence is a lower category offence or whether it's a higher category offence. And when they decide that it's a higher category offence, then they will decline jurisdiction and the case will be destined for the Crown Court. Which brings me on to the next court, which is the Crown Court. So the Crown Court deals with the more serious cases, and those cases which the sentence is more than 6 months. So predominantly you'd see cases of drug supply, such as violent disorder, such as murder, etc., making their way up to the Crown Court. Now at the Crown Court, the formality changes and everything is quite formal. You'll see barristers representing defendants, you'll see solicitor advocates representing defendants, and the judges, and you'll have High Court judges. And everyone within the Crown Court will be wearing gowns, and the barristers will be wearing wigs, judges will be wearing wigs, and solicitor advocates can either choose to wear a wig or choose not to. Some choose to wear them, some choose to not. However, everything is more formal at the Crown Court, unless you're dealing with a youth case. Now, we've discussed previously, there are some cases that are dealt with in the magistrates or the Crown Court. The same rule applies for the youth court. Now, if a youth is charged with what's called a grave crime, and the rules change slightly, so if the magistrates believe that this offence is a grave crime, therefore after conviction the young person will be getting a sentence of 2 years or more, then that case will automatically go to the Crown Court. At the Crown Court, the difference is, number one, the length of time that it takes for the trial to take place. This case will be given priority, and second is that there will be less formality, such as the barristers will not be wearing wigs and gowns, the judge will not be wearing a wig and gown. However, all the other formalities will still be there. The young person is still entitled to have an appropriate adult at the Crown Court. Now at the Crown Court, the major difference is that the person or persons who are in charge of the destiny of the accused is the jury, the members of the jury. Now, a lot of our viewers may have been summoned in the past for jury service. Now, this is a legal obligation upon all of us, if you are summoned, to spend that 2 weeks or more, as it may be, serving the jury. Now, this is quite a unique approach, and it's what makes the British law quite fair and quite just, because what's going to happen is your fate is going to be decided by ordinary members of the public, maybe me, maybe you, maybe someone else, with their life experiences, and they're choosing to see whether or not they believe the prosecution or whether or not they believe the defense. The members of the jury are the ones who decide on that fact, whether or not the person is guilty or not guilty. It's the judge who decides on any legal arguments of law, and if there's any questions regarding law or any issues related to law, it'll be the judge, and it's the judge who conducts the sentencing. So the jury members are only there to hear the facts of the case from the prosecution, hear the defense side, to deliberate amongst themselves, and then to come to a verdict of either guilty or not guilty. Now, the next case is the court is the Royal Court of Justice, and here we find all cases of appeal. Now, the appeal may be, insofar as criminal cases are concerned, an appeal against conviction, where the person is stating that I've been convicted, however, there was an error, and as a result of that error, I've been wrongfully convicted. Or the second aspect is an appeal against sentence. Now, in order to pass to the Court of Appeal, the appellant must show that the sentence is manifestly excessive or wrong in principle. And it's not just good enough to say that the sentence is a bit high, it has to be manifestly excessive. So quite unordinary, so quite above what's usually given. So what your solicitor or your barrister will do in those circumstances is have a look at the facts of the case, have a look at the sentencing guidelines, have a look at other case law and other cases that have been before the courts in a similar circumstances, and have a look at, in their opinion, what the sentence ought to have been. And if they believe that it was manifestly excessive or wrong in principle, and then they will appeal on your behalf. Now, the other courts that are within the Royal Courts of Justice are the High Court and the Administrative Court as well. And then the final court you have is the Supreme Court. Now, the Supreme Court is the final court of appeal as an appeal court, and it cannot consider a case unless relevant orders have been issued by the lower courts. The Supreme Court is the final court of appeal for all United Kingdom civil cases and criminal cases from England and Wales and Northern Ireland. And there'll be arguments of law and which are of general public importance. And what the Supreme Court does is concentrates on cases of the greatest public on constitutional importance. And it's not all cases make their way to the Supreme Court. It's only cases which have a particular public interest or a new area which has not been challenged before that make themselves before the Supreme Court. Now, I hope I've been able to address in brief the different types of courts before England and Wales, and the different type of cases that go before them. Now, ordinarily, what we find ourselves is on talk shows, majority of the questions are relating to immigration and are in relation to bringing a spouse over, etc., or bringing a visitor over from Pakistan, India, Bangladesh, etc. However, what we've chosen to do is to concentrate on criminal law, and on each and every episode we'll discuss another area, and if the viewers would like us to touch a certain area, please contact the control room, notify us that you are interested in learning a bit more about this. It may be the career path of how to become a solicitor or how to become a barrister, and what qualifications are needed, what training is needed, and what types of work that they are. As you know, that lawyers specialize in a certain area of law. Now, I specialize in crime, and other lawyers specialize in conveyancing, such as buying and selling houses, and other lawyers, family law, dealing with divorces, child contact, etc. Some deal with civil cases. It may be personal injury lawyers, it may be regarding disputes, and then we have other lawyers dealing with commercial aspects such as buying and selling properties, etc. At Just Law, we will take all questions from you regarding any area of law. If there are any questions which I cannot give an immediate answer to, I will note the questions down, and the following week I will answer those questions to you. And you also have the opportunity of emailing in questions and asking us regarding those questions, and I will attend the following week with answers to those questions, so all of our viewers can benefit from those questions and those answers. And I will urge our viewers to contact us if there is any specific topic that you would like to discuss, and I will discuss that issue with you. Now, insofar as the next week program is concerned, I believe we should look into the rights and entitlements of a person in custody, what the legal rights are, what your rights as someone who is related to that person, what you can do, what you can't do, and what the position is, and generally what a charging decision involves in a criminal case, what the Crown Prosecution Service or the police will look at to make a charging decision, and when a case gets to the court, what happens and what your rights and entitlements are, in particular regarding representation and criminal legal aid, how it works, etc. So I believe that that is an important topic that our viewers will benefit from, and I will talk in great detail next week regarding that issue. And if there is any other issue that you would like to discuss, please feel free to let us know. I hope you found today's show quite interesting, and you've learned some information that you did not know before. I would welcome any feedback, any questions, any comments regarding today's show. And that's all for today, and we will see you next week. Thank you very much.